Welcome back to Law Call. Again, we're taking your calls tonight talking about fighting the insurance company. Give us a call, 850-392-1544. And Ted, while we were on the break, we actually got an email question in from Rob. We're going to put up on the screen there. Rob has to say, I was working for a friend and I twisted my back and I got a herniated disc. Real bad pain for 6 weeks now. This lady told her insurance and they were nice and sent $1,000 to cover the bills. But after the MRI and the chiropractor, that $1,000 is gone. I need 2 more steroid shots and physical therapy. I called the insurance guy back and he said they'd pay for 1 shot, but I have to sign a release. I need some advice, please. You know, Ted, we get a lot of questions like that, you know, before people come in to see us. They've been involved in a wreck, and contrary to popular belief, a lot of people, the first thing they do is they don't necessarily call an attorney, even though they should, because we need to get involved in this as quickly as possible. But oftentimes they go, you know, obviously they get their medical taken care of. Right. But oftentimes before they come to see us, they've already talked to the insurance company, and one of the #1 tactics is to try to resolve the case early for as little money as possible. But Ted, what happens if somebody, you know, they say, oh, $1,000, that's a lot of money. I'll be happy to take that. I don't think I'm too bad. But what happens if they take that money while they're still getting medical treatment and they don't really know what the future holds?
Right, and that's a problem, is because a lot of people want to have all of their medical expenses paid for as they go, and the at-fault party insurance is typically not going to pay as you go along with the claim. That's why you have the PIP benefits in an automobile accident, but unfortunately this doesn't sound like it's an automobile accident, so the insurance company, the at-fault party, will not typically pay for medical treatment as you go. So they try to lure you in with payments to try to appease you and try to get you to sign a release so that they can be exonerated from any future liability. And lo and behold, if this person who has this herniated disc in this email, ultimately those injections, for example, we don't know if they're going to give any relief, how long of a relief they're going to have, and if this is going to ultimately lead down a path where this individual may need some more substantial or even a surgical procedure, and then you've already signed a release, and that would eliminate any future liability from the insurance company or the at-fault party that caused this. What I would question is if they're not paying, particularly depending on the nature of this policy, if they're paying under a medical payments coverage provision, which does provide insurance for medical bills, irrespective of fault in certain situations, that typically is in a $5,000 to $10,000 range, sometimes even less. So it'd be very, very important to speak with an attorney before you sign any sort of release so that you understand exactly what rights you have, exactly what rights you're giving up by signing that. And it's always dangerous to sign away any rights this early in a claim when you still don't know the full nature and extent of the injuries that you're dealing with, because sometimes it can take quite a time for these things to manifest fully and for you to really have a comprehensive idea of what you're dealing with. And if you sign away those rights, that's it. We have had situations, Les, where this has come into our office and for whatever reason the insurance company didn't document the release correctly and we were able to navigate around it. But a lot of times we have to tell the individual, we're sorry, we can't help you. You have signed away your rights and it's over. And that's a very, very difficult conversation I have. I don't like having it, and it can be avoided if you'll pick up the phone and call us before that and have that release reviewed and have your options fully explored so that you can go in with it, you know, eyes wide open. If you want to settle it, that's your God-given right, but you need to do it fully educated and with the knowledge of what you're giving up.
Well, and if you don't know what you're doing, you really, it's one of those things, you don't know what you don't know.
Exactly.
You know, and we say that kind of jokingly, but that's really the case. If you try to handle the claim on your own, then you're really getting into some uncharted territory unless you happen to be an attorney or an insurance claim representative and you understand the process. You know, going at it alone may save you some money on the front end because obviously we work on a contingency fee basis, meaning we don't charge by the hour. So if you get an offer, if you get in a wreck and somebody wants to offer you money and they're putting a release in front of your face, give us a call. We look at those things all the time and we'll tell people, hey, this is a decent offer. You know, this is all you're ever going to get because the coverage is this and your injury is that. Or sometimes people come in and say, well, they've offered me this amount of money, and we look at the coverage and we look at the medical treatment and we go, your claim is worth way more than what they're offering you, and oftentimes we can help them recover exponentially more money to when you even take the attorney fees into account. You're still getting more money than what you would have gotten if you had done it on your own. But beyond just the value side of it, which that's what attorneys do, we add value to these types of claims when our services are needed. There's also other types of pitfalls that if you're handling a claim by yourself, you can really get into trouble. And that kind of comes with when you have other benefits, things like health insurance, things like Medicare, things like Medicaid. When you get involved in a wreck, you don't lose your rights to get medical treatment that is covered by your health insurance policy, or if you're a Medicare recipient or a Medicaid recipient, or if you're in the military, you have TRICARE, you're going to still get your medical treatment, and those insurances will oftentimes pay for that medical treatment, even if it's from an accident, even if it's from an accident that somebody else caused. But when those companies step in and pay those medical bills, there's a provision in their policies that say, hey, look, if we end up paying medical expenses that you incurred because somebody else injured you, and you get compensated from that person, presumably for medical expenses that we have paid for, we got to be paid back. And it's called a subrogation or a right of reimbursement provision in the policy, but every one of those policies have them. If it's a TRICARE plan, a Medicaid, Medicare or Medicaid plan, the state or the federal government has statutes that enforce that. And if you blow one of those liens, if you have a claim that you're handling on your own and you forget to pay back Medicare or take their interest into account, which is the magic buzzword, if you fail to do that, you're facing some pretty hefty fines to the tune of what, Ted? About $1,000 a day?
Yeah, they're very substantial, and they could even suspend your benefits for a
Right.
period of time until you've compensated them for that loss. And we've had that call before. Someone settled their case, and I didn't know I had to pay back Blue Cross Blue Shield. I didn't know I had to pay back Medicare, but it's absolutely something that you're obligated to do. And so, once again, it's important that you talk to somebody so that you can figure out what you do not know and make sure you're making an educated decision when you resolve the case.
That's right.